We've had numerous scheduling issues, but Professor Josh Blackman.
I'm the pinch hitter.
Yes, in the bottom of the nine. We really appreciate him coming in here. He's a true friend of the chapter. And so we are going to be doing a Supreme Court roundup today. Rather topical, as considering today is the first day of the fall term. And there's no one better to do this than Professor Blackman. Professor Blackman is a tenured professor of law at the South Texas College of Law and an adjunct scholar at the Cato Institute. He earned his JD from George Washington University.
Mason.
George Mason,
the other George.
I'm blaming the timing. And he clerked for the Honorable Danny Boggs on the Sixth Circuit. Professor Blackman is one of the most prolific authors in the country and has written about the Supreme Court extensively, especially regarding the Obamacare trilogy, which has published one of his 3 books on. You may recognize Professor Blackman as a regular contributor to the Bullet Conspiracy and the founder of the premier fantasy SCOTUS league in the world. I'm happy to turn it over to a true friend of the chapter, Professor Josh Blackman.
Thank you so much. I am not Judge Boggs. I am not Philip Hamburger, but I am very happy to be here. I understand they were not able to make it, and I'm happy to step in their place. And today's a very fitting day. Today is the first Monday in October. It's actually a statutory holiday of sorts, at least for me. It's the official start of the Supreme Court's term. This morning, if you tuned in to oral argument, you would have noticed that you can. For the first time ever, the Supreme Court is live streaming argument from its website. It's still sort of stunning to even think of that. For the last 18 months or so, the court would basically give C-SPAN access to its teleconference line, and you would listen to this staticky, call on C-SPAN's network. But now you actually have audio from inside the court being live streamed. As it turns out, the justices have a slightly modified format. They allow the attorneys to have an opening statement. Then they have the usual questioning. And at the end of the questioning, every justice gets a chance to ask a few more questions. I thought it was very effective. Justice Kavanaugh was not on the bench today. He is home quarantining with COVID. He is asymptomatic. Hopefully he makes a speedy recovery back to the court. But this term is already getting off to a huge start. Let's start with some numbers. I think the magic number this year is 6. For the first time in any of our lifetimes, there are 6 conservative members of the court. Now, there have been 6 Republican appointees. That's happened several times before. But don't confuse a Republican appointee with a conservative. We've had many Republican appointees who turned out to be quite moderate or quite liberal. Indeed, in 1990, when Planned Parenthood versus Casey came to the court, there were 8 Republican justices. And the one Democratic justice, Justice White, had dissented in Roe. So we've seen now perhaps the most conservative court since maybe the New Deal, maybe even a little before the New Deal. We're going back way, way back. But the next number to think about is not 6, but 3, specifically 333. I think it's unfair to say we actually have a 6-3 solid conservative majority because the justices fall into 3 different ideological camps. We have the progressives. We have Justices Breyer, Sotomayor, and Kagan. And in most politically charged cases, they tend to vote in unity, although they do have some mild disagreements among them. Perhaps Kagan and Breyer are a little bit more moderate, and Justice Sotomayor goes further. We also have the 3 most conservative members of the court. We have Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch. And again, from time to time, those 3 split up, but usually you have Thomas, Alito flanking to the right, with Gorsuch there most of the time. But then you have the middle of the court. And when I say the middle of the court, I don't mean they're moderates, right? They're to the right. But wherever the middle is of this court, that's the center. It's not that they're ideologically centered. They're the middle of this current court. And those are Chief Justice John Roberts, Justice Brett Kavanaugh, and Justice Amy Coney Barrett. I've called this court, I think I was the first, if not one of the first, the 333 court. Because in any given case, you need 5 members to make a majority, and that means the court's progressives need to pick off 2 of the 3 moderates. So if Breyer, Sotomayor, and Kagan get the Chief and Barrett or the Chief and Kavanaugh, they have a majority. And last term, we did not see a monolithic 6-3 court. It simply didn't happen. In fact, the court went left more than went right in these divisive cases. Let's give some more numbers. The next number I want to talk about is 83, the age of Justice Stephen Breyer. Justice Breyer is 83. As best as we can tell, he's in very good health. But there's a never-ending movement to try to get the guy to retire. He won't be left alone. No matter where he goes, people are asking about his retirement. I tend to think the more people urge him to retire, the less likely he's going to retire, because it'll be seen like he's reacting to political pressure. Perhaps Breyer wants to retire at the end of his current term, ahead of the midterms. There's still a slight Democratic majority in the Senate. But then again, Breyer may think he's doing his job very well, and he's able to moderate and build compromise and consensus. He spent 3 decades building this reputation in the court, and I think a new member who just shows up tomorrow may not be as effective. But then again, if Breyer sticks around till 2024 and a Republican president appoints him, he will get the RBG persona non grata treatment and be shunned from all discussion for failing to preserve his seat for the Democratic Party. Keep in mind, we have several senators who are quite up in age. Senator Feinstein's 88, Senator Leahy's 81. And so it's not a guarantee the composition of the Senate stays the same forever. Strange things do happen when we get to Supreme Court justices. We don't all know the time of our death. Justice Scalia sure didn't. Justice Ginsburg sure didn't. Chief Justice Rehnquist sure didn't. And I don't think Breyer does either. The next number I want to reference is 55. That is the number of opinions, the number of signed opinions the court issued last term. This is the second lowest total since the Civil War. Truly. Since the Civil War, this is the second lowest total. The lowest was last year, which was 53, and that was during the pandemic. That's a very low number. In recent years, the justices have decided 80 cases, 90 cases, 100 cases. If you go back to the 1980s, they were arguing almost 200 cases a year. So they've seriously curtailed their primary docket. But what has grown is the drum roll, the shadow docket. Yes, this shadowy docket, the emergency docket, as Justice Alito prefers to call it. The court issued a number of significant decisions in the shadow docket, many of them involving COVID lockdown measures. Now, I think the sort of paranoia about the shadow docket is truly a bit overblown. Many of these cases come to the court on an emergency basis, and they have to decide them on an emergency basis. Granting certiorari and deciding them in 6 months is often not an option. They got to decide them quickly. And it's not always possible to write a fully reasoned, thoughtful decision in a short period of time. The simple question is there a stay or no stay of the lower court injunction? But without question, the court's primary docket has shrunk. And I think they should take more cases on an expedited basis. So, for example, there's a case this term involving a prisoner who's about to be executed. He wishes to have his chaplain lay hands on him during the execution. Texas says no. Rather than issuing a shadow docket order, the court said, let's argue it soon. So in September, they said, let's grant cert. It'll be argued in November. Maybe a decision by December or January. So that takes, about 3-4 months? That is more optimal sometimes when you have the luxury of time. We don't always have that luxury of time. Let's give some more numbers. 26. That is the number of unanimous decisions. So of the 55 signed opinions this year, 26 were unanimous, 9-0. That's about 47%, about half. What about 8-1 decisions? 60%. So nearly 2/3 of both dockets were either 9-0 or 8-1. There were 12 6-3 opinions where there were 6 conservatives in the majority. There were 6 5-4 decisions. 3 of them went to the left, 2 went to the right, and 1 were more mixed. So the court is very hard to divide on this sort of ideological base. I know it's useful as a sort of a proxy, but the justices do disagree, and they do vote in unpredictable ways. Okay. All right. Let's move on. We have also the next number, which is 97. 97. Justice Kavanaugh was in the majority 97% of the time. That is the highest rate in a long time. It's hard to get that high. Chief Justice Roberts hit that once, and Justice Kennedy hit it 3 times. Now, I think it's safe to say that Justice Kavanaugh is the median justice. That doesn't make him the sort of swing moderate that Anthony Kennedy was. But where the court is right now, Brett Kavanaugh is in the middle. Roberts and Barrett were in the majority 91% of the time. Again, that's where the 3-3 court comes in. Gorsuch in the majority 90% of the time. Justice Sotomayor was in the majority only 69% of the time. Which justices agree the most? Roberts and Kavanaugh agreed 94% of the time. Who had the lowest rate of agreement? Justice Sotomayor and Alito. They were 53% of the time. A few more numbers. 80. The court reversed 80% of the time, which is higher than in recent years. The next number, or perhaps numbers, is 1 in 15. That is the Ninth Circuit's win-loss record. 1 case in Ninth Circuit was affirmed, and 15 were reversed. That's a 94% reversal rate, which sounds really bad until you get to the Sixth Circuit, which is where I clerked, which went 0 for 5, not 5 reversals. So I think you have a very sharp reversal rate for at least 2 of these courts. The court's liberal bloc was in the majority in 13 of the 28 decisions. There were only 6 what you might call hardcore partisan 6-3 splits. So 6 out of 55. That's not a huge percentage, but those are the cases people care about the most. All right, let's start cleaning up the docket from last year. There were a number of cases that I'll just call Trump law. These were cases in which various Trump policies were appealed to the court, but because of the election and the change in administrations, these courts fell off the docket. One was Wolf Innovation Law Lab. This was a Remain in Mexico policy. The court granted cert in October, dismissed as moot after the election. Trump versus New York. This was a case involving whether the census could include a citizenship question. Dismissed. Case is gone. Trump v. Sierra Club. This was about the border wall. This case was knocked off the docket with instructions to vacate. And there were several others. So the 55, the number of signed opinions, is perhaps lower than expected. But in some part, I think that's because a lot of these cases simply fell off the docket. Okay, and I see there are questions coming, and I will get to them at the end. But please just keep putting them to the chat. I will get to them at the end. All right, let's turn to some of the merits cases they did decide. The big one, which Bradley mentioned, was the Obamacare case, California against Texas. None of you remember this, but I've been to your law school at least 3 times talking about Obamacare over the years, my various books, maybe another time next year. Obamacare is a gift that keeps on giving. This case sort of felt like Groundhog Day. It's this sort of cycle that keeps repeating. Congress reduced to $0 the penalty in the ACA's Affordable Care Act. Texas and others argue that this rendered the ACA unconstitutional. I filed an amicus brief in support of the private plaintiffs. What the hell do I know? I lost 7-2. When I am too conservative for Clarence Thomas, I need to reassess my priors. Perhaps it's a good wake-up call. But the court dismissed this case on standing ground, which was not an unexpected result. I thought I had a way around it, but my way didn't work. The justice held that because the government doesn't actually enforce the mandate, there's no redressability, and there's nothing for the government to do. Therefore, Article 3 standing is lacking. The court would not consider what I call standing through inseverability, which just there was no interest for this on the court at all. Oh well. Let's turn to the First Amendment and a case from Philadelphia. Fulton versus City of Philadelphia. Here we have Catholic Social Services. This organization has been doing adoption services for almost 200 years in the city. It's a very important service for children. But the Catholic Social Services follow the teachings of the Catholic Church. And they would only place children in married couples with opposite sex couples. They would not place children with same-sex couples or even unmarried couples. The facts are actually quite muddy over whether this was actually ever enforced, and I don't want to get into that. But the court ruled 9-0 against Philadelphia. But on very narrow grounds, the court said, well, maybe you can give an exemption to Fulton and the Catholic Social Services, right? You give exemptions to other people. If you have exemptions for one, why not for others? The court didn't say very much about the free exercise clause. Now, the big change came in the concurrences. Alito, Thomas, and Gorsuch concurred, saying we need to overrule Employment Division versus Smith. In other words, we want to review free exercise claims with strict scrutiny. Barrett and Kavanaugh, joined partially by Breyer, concurred. And Barrett, which this is a first writing of substance as a justice, said, well, I don't know that Smith is wrong as an originalist matter, but maybe we can overrule it later. But I have some questions to think about. I got to admit, I was kind of disappointed. I mean, if you haven't thought about Smith yet, it's been around for 30 years. Most sentient law professors have given this issue some thought. It seemed like a cop-out, like a punt, right? Michael McConnell's article has been published. It's either right or wrong, overruled or not. I was disappointed. It's like Justice Thomas during his hearing. I hadn't thought about Roe. You're a law professor. Think about Smith just a little bit. All right, let's move on. The next case is Americans for Prosperity versus Bonta, B-O-N-T-A. California had a policy that required nonprofits to submit their donor lists. Various nonprofits sued. This is a case that should not have been ideological. You had the ACLU and the NRA on the same side of the case, which doesn't happen very often. These groups said it would chill their free association to require disclosure of donors. I think that's right. But the court split 6-3. Justice Sotomayor had a very vitriolic dissent. She was very worried that this case would upset other types of disclosure laws. For example, the IRS requires the same information. She's probably right. So I think the court is definitely trending against mandating disclosures, which is sort of in tension with even Citizens United, where the justices upheld the mandatory disclosure policy. The next case is what you might call the nasty cheerleader case. Brandy Levy failed to make her school's varsity cheerleading team, and she did what all teenagers did. She went on Snapchat, and she tweeted pictures using the vulgar language, the F word, as well as lifting up the middle finger because she was frustrated with her decision. Brandy was then suspended from the JV squad, and she sued, which is what all high school kids do apparently when they get in trouble. The lower court granted an injunction ordering the school to reinstate her. The Third Circuit affirmed, although on slightly different ground. This case split 8-1, and the one dissent was not surprising. Justice Thomas was in dissent. He does not believe that children have any rights at all. Zero, zilch, none. When a student enters a schoolhouse gates, the teachers are on loco parentis. They have no rights. He's very clear about that, so he's consistent. Justice Breyer wrote the majority, which, if any of you actually care about free speech law, you should be, oh my God, not Breyer, right? It's an opinion that's very hard to follow. It's a multi-factor test that will give administrators very little guidance over when they can and cannot punish. This is a case where sort of for the price of unanimity, the court sacrificed clarity. I would have much preferred a 5-4 sharp decision that gave guidance and this sort of 8-1 wishy-washy, who knows what it means. These issues will recur. There'll be more student discipline for social media, especially if students have been on Zoom for the last year and a half. A lot of learning happens outside the classroom. It happens apparently in bedrooms now. Well, you guys are in school. I'm sitting in my office at home. Let's talk about separation of powers. We have a case called Collins versus Yellen, Yellen. She's the Secretary of the Treasury. This case was a frontal challenge to the Fair Housing Finance Agency, the FHFA. I always get the acronym wrong. The FHFA is this massive organization that regulates funding involving federal housing. I'll leave it there. The director of that agency took some action that annoyed people, and they sued. And they argued that the director is unconstitutionally structured. He's a single director who can only be removed for cause. So the court went 9-0 here. All 9 justices agreed on that this agency is unconstitutional. But the justices split sharply on the remedy. What the majority said is we will simply sever the protections. That is, you can remove this person for any reason at all. There was no appetite to kill the entire agency. There's no kill shot here. And indeed, President Biden fired the director, who's a holdover Trump guy. So, as it were, the conservative ruling gave Biden a free pass. Let's do election law for a minute. Brnovich versus DNC. He's the Arizona AG, Mark Brnovich. Arizona had 2 election laws at issue. One said that if you vote in the wrong precinct, your vote will be thrown out. The second regulated ballot collections. That is, only certain people can collect ballots. Family members, caregivers, mail carriers, etc. You couldn't hire organizers to go door to door and collect absentee ballots. As far as voting restrictions go, these are pretty modest. This was not the test case that anyone wanted for voting rights, but they appealed to the Supreme Court. The court upheld these rules by 6-3 vote. Justice Kagan wrote a very, very pointed dissent. Again, these rules were not particularly onerous in comparison to other rules that have been enacted. But Justice Alito was sort of looking ahead, said there's certain incidental burdens of voting that, deal with it, right? It's just mere inconveniences. And the mere fact that something imposes a burden on voting doesn't mean it's a violation of the Voting Rights Act. Alito said we look to the totality of the circumstances and all these other factors. So it's very hard, I think, now to win a voting right challenge under Section 2. We'll have more litigation with the Georgia law and the Texas law and other states, but this precedent does not augur well for the types of restrictions that are being challenged in the courts right now. Let's do a Fourth Amendment case. I love this case. Taurus versus Madrid. This is like a fact pattern from like a law professor's craziest dreams, right? So you have 2 cops who are executing a search warrant, and they see a woman in the parking lot. At the time, she was actually going through meth withdrawal, so she wasn't acting very normal. They approached her. She didn't know who they were because they weren't in uniform, and they told her to stop. At that point, she gets in her car, and they approach her car. She thinks she's getting carjacked, so she starts driving away. The officers fired their guns. They shot her twice in the back. They paralyzed her left arm, yet she somehow drove 80 miles to a hospital with one arm. I have no idea how this is even possible. This is like Wonder Woman, right? She's just getting shot and keeps going. She brings suit under Section 1983 for depriving her of her civil rights in violation of the Fourth Amendment. But here's the question. Was she seized? Was there a seizure for purposes of the Fourth Amendment when the person doesn't stop? If the person keeps going, is there a seizure? This was a hard case. Actually, I think one of the hardest cases this term. The court split 5-3. 5-3. Barrett did not participate. The chief wrote the majority, and he said a seizure occurs when a person temporarily eludes capture. Gorsuch is like, Roberts, you're making crap up. This is not true, right? A seizure requires seizing. The mere fact that a bullet touches you is not a seizure. I am probably with Gorsuch in this one, but I think this is a really close call. I think there's decent history going either way. So I don't have a strong opinion, but I think on balance, Gorsuch has the better answer. All right, let's do Fifth Amendment takings clause. I also teach property. Cedar Point Nursery versus Hassid, Hassid. This is probably the most significant property case in decades. I mean, decades. This is one that went 6-3 hard right. California had a regulation on farms. Farmers were required to give union organizers access to their farm for up to 3 hours a day, 120 days a year. This is a significant intrusion on their property rights. The Supreme Court found there was a per se taking. If you don't know what per se means, it means automatic. There's no balancing involved. And I think the Chief Justice, as he often does, was very fluid with precedents. He sort of picked apart various precedents that were favorable to property rights, and he basically concocted new tests. I think this changes takings law in a radical way. It's perhaps the most significant takings opinion in decades. If you're already taking property, you probably won't have a chance to read it, but just read this opinion. Breyer in dissent, like, what are you doing, Roberts? You're making it so much easier for people to win takings claims. It's going to be so much harder for government to regulate property. Yeah, that's the point, right? This is a full-throated defense of property rights. We may recall Roberts wrote the majority opinion, Horn 1 and Horn 2. So he has a strong, Roberts, for whatever his warts, has a very strong feeling for property rights. So that's something that we can keep in mind. All right, let's look ahead to next term, which I guess begins today. We had arguments this morning. I listened to them already. The case this morning was about water rights. It was Mississippi versus Tennessee. I don't think you care about aquifers. I'll pass on that for now. All right, the first big case we'll have involves guns, in fact, in your backyard. New York State Rifle and Pistol Association versus Bruin. If any of you New Yorkers wish to obtain a concealed carry permit, good luck, you won't get one. The state has a standard that says you only get a gun permit if you have good cause. What is good cause? It doesn't mean you want to defend yourself. You have to persuade some official in the government that you're special. And this invariably involves favoritism. If you're good friends with the sheriff, or you're politically connected, or a celebrity, you'll get your permit. If you're a regular Joe Schmo, or Jane Schmo, or Jane Roe, you're not getting anything. This is a case that considers whether this standard is unconstitutional. Of course, the city can still deny permits to people who pass background checks and who fail background checks. But this is, does the city have the power to deny your Second Amendment right to carry a gun based on cause? To get there, the courts to decide, is there a Second Amendment right to carry a gun at all? The court has resisted this question for, my goodness, nearly a decade. McDonald was from 2010. But I think now there are 4 votes. For reasons I'll make clear in about a minute, I don't know that the gun owners win this one. I think they might lose. In fact, I don't think there are 5 votes for the Second Amendment here. I think actually when the liberals granted cert to try to force the issue. The next case, I think, will explain why I'm so skeptical on the Second Amendment, which is Dobbs. Dobbs versus Jackson Women Health. This is a case from Mississippi. Mississippi had a law that prohibits abortions at 15 weeks. This is clearly unconstitutional under Roe and Casey, because Roe and Casey says you can't ban abortions before the viability line. And depending who you ask, viability is 24 weeks, 22 weeks. I mean, we can argue all day what it is, but it's not 15. It's not. There's no viability of 15 weeks outside the womb. So what are the court's options in Dobbs? One option is simply say, well, this is unconstitutional under Casey, go home and affirm straight up. That's option number 1. Option number 2 is they say, well, Roe and Casey are wrong. We're ruling one or both of those cases. You got to rule over both of them. And Mississippi can act whatever it wants. Now, everyone wants to say, what was option number 3, Josh? I usually think there was a middle option, but I've actually moved away from that. I don't think it works, right? So imagine what option number 3 would be. The court says, well, Casey drew the line of viability, but we'll draw the line somewhere else. We'll use some other standard, right? In order to do that, the court would need to reaffirm substantive due process. Or the court has to say, Roe was correct to recognize an unenumerated right to abortion based on the right to privacy from the penumbras. We agree with that, but Casey drew the wrong line. That's a hard pill to swallow. I don't think John Roberts can swallow that pill, right? If you read his Obergefell dissent, he was excoriating a substantive due process. I mean, I don't know that Kavanaugh and Barrett can swallow that pill. So I think they have really two choices. Uphold Roe or uphold the Mississippi law. I don't think there's a middle path, right? This is not Anthony Kennedy who can write about the mysteries of life and the sweet mysteries and the unparalleled dimensions of liberty and whatever the nonsense he could cock up. They can't write that. These are sober judges. I don't mean sober that they're alcoholics. They're serious judges. They're not writing the fortune cookie aphorisms, right? We saw in Obergefell, right? They can't write that opinion. If Roberts says, I think Roe was wrong, but based on stare decisis, uphold Roe and Casey, I can live with that. I think he can do that. But the sort of middle of the road where he redefines Roe and Casey would require to reaffirm the basis of Roe and Casey, which is just substantive due process. That prediction brings me back to guns. Imagine this term the court says, Mississippi, you guys can ban abortions, but New York, you can't ban guns. Oh. So I think the court goes up on both or goes down on both, right? If the court upholds the Mississippi law, I think they have to uphold the New York law. I think they're going to have to find a way. They're going to just squish in the Second Amendment. It would be very incongruous for those who care about public perception, which Roberts does, to say, New York, you can't restrict gun access, but Mississippi, you can restrict abortion, just in the same term. So even though I'm a longstanding advocate of the Second Amendment, I am not confident that the gun case goes for the conservatives for a lot of reasons. There's so many ways. Maybe the court writes an opinion that's favorable. It says maybe New York standard's fine, but remand and reconsider. There's something, but I think the people of New York are going to be stuck with this good cause standard for some time. What other cases is terms? Carson versus Macon. This considers school choice. Right, the state of Maine prohibits funding of various funding for religious schools, and they said, "Well, we're not discriminating on the basis of religious status. We just don't allow you to use money for religious uses." This goes back to a case called Trinity Lutheran. Is there a difference between religious status and religious use? Of course not. Roberts had a footnote to try and keep Kennedy, but he's gone. So I think the court will have to just knock down that distinction. Whether it's affirmative action. Yes, my friends, affirmative action. Students for fair admission versus Harvard, that other Ivy League school up the coast. Harvard uses racial preferences. They have policies that, be frank, punish Asian students. You can crunch numbers however you want, but the numbers are not flattering. The school argues they need these policies to promote diversity. This is not a 14th Amendment case. It's a Title VI case because Harvard is a private school. The standard for Title VI is probably the same as the 14th Amendment, but they might say it's different. Maybe the 14th Amendment standard's more permissive, or who knows. But I suspect the court might grant this case in December if the Solicitor General moves promptly on a request, but it might get kicked to next term. All right. I have a lot of questions in the chat, so let me start going to the questions. Let me start going to some questions and see what we can do here. Okay. First question, and please, there are other questions. Please put them into the chat. First question: what do you make of the justices seemingly striking back in its media reports about the shadow emergency docket and the media's reporting on them? Look, I think there's no coincidence here. In the last 3 or 4 weeks, several justices have come forward to talk about the docket. We had Justice Breyer, Justice Barrett, Justice Alito, Justice Thomas, and they've all had the same refrain that we're doing our jobs. We're getting the cases, they come to us. But I think they're worried. And the reason why the shadow docket thing is so, I think, pernicious is it creates the impression that the justices are deliberately deciding cases in the dark of night to avoid scrutiny, which is nonsense. If there's an execution at midnight, they need to get the ruling out by 11:58, right? And they're going to take every minute they can to get there. In the recent abortion case, the clinics came to the court asking for relief in 24 hours. It took about 48 hours. And if you notice, Justice Sotomayor wrote a dissent, and her dissent actually cited articles that were critical of the court for not ruling right away. Right? Her dissent cited articles that were after the 24-hour deadline, which means that she was probably holding things up. Right? So I think a lot of this has to do with the justices getting their job done as quickly as possible. The death penalty cases have been sort of a mess forever. Advocates throw petitions up at the 11th hour, hoping to get some sort of chaos and get a stay, but that often doesn't happen. We'll have fewer shadow docket cases this year as a matter of course. One, the Biden administration will simply not be as aggressive as Trump was. Trump was very aggressive with shadow docket. Biden will not be. Two, God willing, the COVID cases should fade. So many of the shadow docket cases last year involved COVID restrictions. I think those are, thankfully, hopefully, praying behind us. I mean, unless you have some sort of variant that breaks the vaccine altogether, we should be at a normal place. So I think this criticism will fade. People writing books about it will have to, just rub at old cases. All right. Next question. Thank you so much. Next question is about SB 8. Okay. And do you have thoughts about Justice Sotomayor's comments on SB 8? Well, let me talk about SB 8 for a minute, and I'll get to the Sotomayor part. When I talk about SB 8, I want to talk actually about Holmen's health first. In 2017, the court decided Holmen's health versus Hellerstein. This was a abortion law in Texas that restricted various things. It said if you were a doctor to perform an abortion, you need to have admitting privileges to a hospital nearby. The law also said places where abortions are performed have to meet surgical standards, even if they don't perform surgical abortions. There are other things as well. For example, the law said abortion clinics must have smoke detectors installed. Okay. The case goes to the court, and Justice Kennedy cast a fifth vote to say that the entire statute is unconstitutional. Everything. Even the smoke detector provision, right? That Texas cannot require smoke detectors in abortion clinics because that would impose an undue burden on abortion. I got to tell you, that decision did not sit well in Texas where I live. It was like, we lost on smoke detectors. You couldn't just sever that part out. SB 8 was born from that frustration. So SB 8 outsources enforcement from the government to private parties. The government has no role to enforce the law. I'm going to put aside the judges for a minute, right? The attorney general, the executive branch cannot enforce this law. It can only be enforced in terms of private actions, private litigants bringing lawsuits. There's no question why they enacted this sort of cockamamie law. It was designed to avoid a pre-enforcement challenge. Right? They knew what happened to Holmen's health. They want to avoid it. That Planned Parenthood runs to a favorable judge in Austin who grants an injunction, and the law never goes into effect. This was designed to avoid that. And they took advantage of a little-known aspect of jurisprudence that when you sue the government usually is bound in all regards. But when you sue a private litigant, they're not bound. And who are you going to sue? Right? Ghostbusters, who are you going to call? Right? Who are you going to sue? Planned Parenthood and other clinics decide to sue everyone. They tried to sue all the judges in Texas. Well, they sued one and they want to certify a class. And thinking was, if we enjoin state court judges from hearing the case, the law can't be enforced. It actually could in diversity, right? So if someone in another state sued in diversity jurisdiction, go to federal court. So it wouldn't even stop the law, but in theory, it would stop a huge portion of it. The district court said, yeah, you can sue judges. They're involved. The circuit court put that on hold. Okay. As the case reached the Supreme Court, there was only one judge. Judge Jackson lives in East Texas. Only one judge. They had not certified a class yet. even if the court granted all the relief the clinic sought in that case, all they could have done was enjoin Judge Jackson. If you want to talk about shadow docket abuse, the remedy that was being proposed was insane. The clinics want to vacate the trial court injunction or the trial court ruling so they can reinstate a broader case against all the judges in Texas, which is nuts. There's no way they could have actually won that case. If you read the dissent from Roberts, from Kagan, from Sotomayor, from Breyer, they say, let's enjoin it. No, you don't enjoin laws, you enjoin people. And there's no one to enjoin in this case. Right? Let's issue a stay. A stay of what? That doesn't do anything. So I challenge, to this day, anyone to think of what remedy the court could have actually done that would have stopped the law. It couldn't. The lawsuit that actually has some teeth is actually the DOJ lawsuit that's pending before district court now. Those arguments on Friday. DOJ sued Texas, and they sued you. What do you mean? DOJ said any possible litigant is now a defendant. And that's not just Texans. All of you sitting here in Morningside Heights are now actual defendants. Mazel tov. Congratulations, right? You are now litigant in federal court. I'd love to intervene to argue on behalf of myself, but I don't think it's in the cards. But the real rub is, again, the state judges, right? The United States can sue a state. Sovereign immunity doesn't attach. So that's actually to the benefit of the United States. The harder part, though, is injury, right? What's the injury? SB 8 doesn't regulate the federal government. Now, there might be cases where Texas burdens, imagine federal prisoners in abortion or immigrants in federal custody. So there might be some narrow context where the federal government wins on preemption. Very narrow, but it doesn't stop the law. I describe SB 8 as like the Hydra. You cut off one head, two heads grows in its place. You can't stop it. And again, this is against the backdrop of Dobbs. If the court overrules Roe, then SB 8 will become irrelevant. Texas will just ban abortions straight up and enforce it the normal way. So this law is only like a stopgap when the sideshow's going on. Now, finally, I'll get to your question on Justice Sotomayor. Last week, Justice Sotomayor did a Zoom webinar with the American Bar Association, and she was asked about SB 8. And frankly, the answer should have been no comment. And I really wish judges would just say no comment. In fact, Alito talked about SB 8 yesterday. I think he towed the line, but the answer should be no comment. And then Sotomayor said, and I'm going to paraphrase, I don't have it in front of me. She said something like, well, if you guys don't like this law, you should lobby and try to get it repealed. This law is still before her. And I think a justice urging people to lobby it and repeal a law in real time is problematic. Justices say this in opinion sometimes, but the press conference, the press aspect of it, I think is troubling. She won't recuse. It's not going to happen. So it's for nothing. But that's the long answer to your question. Thank you so much. Okie doke. Next question. Okay, I got Brad sent me one in the chat. I'll read this one.
Yeah, I'll read that one.
Oh, thank you. Please.
Someone asked whether you think that the public pressure campaign or the public option will bear any fruit either this term or in the future, either by pushing Justice Kavanaugh to vote a certain way or getting Justice Breyer to retire.
I think it's a good question. I very much dislike this public pressure campaign because it presumes these justices are political knaves, these little naive little figurines that don't have minds of their own. But it worked in the past. I definitely think Justice Kennedy was susceptible to this pressure. Justice Kavanaugh reportedly likes to read newspapers and cares what people think about him. I think the counter to that is it's very hard for a justice to sort of sell himself out. I think the Chief Justice caved to political pressure in the Obamacare decision, and that's sort of thing you don't recover from. Once you do that once, you sort of made your mark. That's who you are, and you have to sort of live up to that standard. So if Kavanaugh decides to fold now for the next 40 years, that's going to be his norm. You make that decision once. Once you make it, once they know it works, you give up. We'll get Breyer to retire. I think he's set. Breyer is living his best life. I listened to him this morning. The case was actually pretty boring about water rights, right, between Mississippi and Tennessee. And Breyer had this cockamamie hypothetical. If you fly an airplane through San Francisco and you collect the fog, you transport that fog to Colorado, or is that an appropriation of water rights? Like, who the hell cares? But he's having fun. And that's great, right? He's really enjoying himself. So I don't see him going anywhere. That was just it was just, and then at the end he said, if you can't answer my question, that's fine. Because it didn't even matter, but he's enjoying himself. So I don't think Breyer will retire, but Kavanaugh might fold. I don't know. I worry. All right. Next question. Not related to your talk, but I was wondering if you had advice for one else interested in academia and your path there. Oh, what a good question. It's not about the Supreme Court for once. I'm happy to answer that question. The key to being an academic is to write as much as you can. And I'm not just talking about your law review note, right? You're all very smart. You're all in Columbia, maybe go in the law review or another journal. You need to write as much as you can. So how do you write? Get to know your professors who write well and become their RAs. By editing their papers and footnoting their papers, you will learn a lot about the writing process. Take seminars with professors you like. And when you take the seminar, have in mind publishing your paper into the semester, right? Don't just treat this as, oh, I have to write 15,000 words and be done. No, actually write 20,000 words. Actually treat it from the outset as if you're going to publish the paper, because you will never come back to it and fix it later. You have to do it at the outset. You have a professor guiding you, etc. And then after you write it, work with your professors to publish it. Some student journals will accept student submissions. You have to find them. They're not always the top ones, but you'll get them. Get publications. There are various fellowships and visiting professorships that you can join, but really show that you love to write. If you don't love to write, this is not the line of work for you. We speak, we teach. Teaching's wonderful. I love teaching, but that's not why you get hired. No one gets hired to be a teacher. Maybe they should, but they don't. But good question. Okay. Done. Okay. Done. Okay. Next question. With Gorsuch on the bench for 4 years now, have you noticed large changes between him and Scalia? My goodness. I think Gorsuch fancies himself as like a Scalia type. I'm not sure if the rule fits. For example, Bostock was the Title VII case. The Title VII prohibited LGBT discrimination. I don't think there's any world where Scalia wrote that opinion. No world. I can't fathom it. In fact, Brian Garner, who was Scalia's colleague in many things, said Scalia would have dissented in that case. On certain Fourth Amendment issues, I do think that Gorsuch is trying to pick up the Scalia mantle. They're similar, and they both kind of vituperative. They're kind of argumentative. They're abrasive. Gorsuch though doesn't have Scalia's charm. Gorsuch comes off as a little bit abrasive, and Scalia had a bit of a charm to him. I don't think he can replicate that. I'm waiting to see. But Gorsuch has written some good stuff in admin law. He did dissent in Gundy. It's good stuff. So far, I'm optimistic. Okie dokie. Next question. Do you think we'll see any additional election-related lawsuits post-Verinovich? Absolutely, I do. There's already litigation in Georgia. There will be in Texas very soon. And they'll have to resolve this pretty quickly. Also lurking in the background as Congress enacts some new voting legislation. I think, not to get political, but the current fighting over the stupid infrastructure and spending bill makes it less likely that Congress actually enacts voting rights legislation. There are only so many days in the calendar. And every day you keep pushing back with this, the infrastructure and the $3.5 bajillion, whatever it is now, right? It makes it hard to pass voting legislation, which might be the most important thing Congress could do this year. The infrastructure could wait. But I think we will see some voting legislation. But Brnovich signaled the court's not going to stop it. Okay, next question. When it comes to precedent and citing cases, what varying weight to justice give pluralities, majorities, concurrences, and dissents? That's a really thoughtful question. I'll give you one example. Chief Justice Roberts wrote a concurrence in a case called South Bay versus Pentecostal Church. It became what I call a super precedent. Hundreds of judges cited Roberts' concurrence if it was law, right? Then we have a case with Roman Catholic Diocese versus Brooklyn, which sort of nullified South Bay. It was a shadow docket shadow docket 5-4 opinion. Judges are still citing John Roberts in South Bay, even though it's not good law anymore. So I think judges cite what they want to cite. If it says what they want to say, they're going to cite it, even if it's just a concurrence or even a dissent. Next question. What examples of picking and choosing do you think Roberts has done other than Obamacare? The census case and the DACA case are two very recent examples. President Trump wanted to add a question of the census, and also President Trump wanted to rescind DACA. I think Roberts substantially modified admin law to get to that result. There's something called hard look. Oh, you guys don't teach admin, do you? Right? Brad told me you don't teach admin at Columbia. Something called a state farm, which is a doctrine in admin law, in which courts can sort of give a hard look at whether there's a sufficient justification. And the type of scrutiny that Roberts applied in the DACA case and the census case is simply stunning. It gives judges the power to Monday morning quarterback every aspect of the decision. Oh, you didn't consider this. You should have considered this. And why didn't you consider this? Of course, you can always post-game it. Those decisions are now being used to second-guess Biden administration. So maybe there's a neutral principle. I doubt it. A question from Richard. If any pre-enforcement challenge to the SBA is impossible, then what does that mean for other constitutional rights? Can New York create a private right of action to gun owners? Yes. If SB8 works, then basically the state can offload any other constitutional litigation. But I do want to counter just a little bit. The reason why SB8 is so pernicious is because Roe is in flux, right? If New York were trying to ban handgun possession, Heller's not in jeopardy, right? The court's not going to rule Heller. So I think gun owners would say, come and take it, right? Because I'm going to win 9-0. But Roe is not so much. Because if the court overrules Roe, SB8 permits retroactive liability. So I think SB8 works precisely because the abortion case was in flux. In other contexts, hate speech, whatever else example you want, you're going to win at the Supreme Court, so don't worry about it. Okay. Next question. All right. Ira. Okay, let's answer your question, Ira. Thanks for coming. Thank you for having me. Do you think liberal states will take up Texas-style restrictions? You just asked that question. Thank you. Great minds think alike. So yeah, I think it's unlikely other states copy Texas' approach in gun rights context. But if the court overrules Roe, again, you don't need SB8. SB8 only works because Roe is in flux.
I think that's all the questions we have right now. But luckily, people have sent me more.
Okay. Sure. So... there's one more. Anonymous attendee. The strongest arguments in favor of originalism. I only have a minute. Look, I think read. Wait, what do you even read? Elon Werman wrote a book on originalism. It's pretty accessible. That's a short one. There's a lot you can read, but I think there are aspects of originalism that make it quite beneficial. Keep in mind what the judges do is often not originalism. Academics sort of do it one way, but. Yeah, good. All right. What are the questions you got?
Yeah, we got one asking here. So we had Justice Thomas actually asking questions during the
Yes, I love it.
My question here, the question the person sent to me was asking, do you think this will continue? And why do you think after 30 years he's decided to start firing from the bench?
Well, so if you listen to the arguments this morning, you'll notice that Justice Thomas asked the first question out of the gate in both cases. I think the justices have an informal agreement to let Thomas go first. There was actually a long-standing informal agreement that Ginsburg would go first. Ruth Ginsburg would always ask the first question. That was just her thing. So I think they're giving Clarence Thomas the first question. That way he won't have to interrupt anyone. And that way Thomas gets his voice in. So I think that's the new rule. And I'm okay with that. Thomas has good questions. He's very thoughtful. And Justice Sotomayor goes, I think Justice Thomas had a good question. Can you follow up on that? So there's important. But I was so happy to hear the arguments this morning, which were normal. They were flowing naturally. I was just so thrilled to hear it. It was like a throwback to, before the pandemic when, this is what we had for 100, however many years we had to record, 50 something years. So I was very happy to hear it.
Yeah, that's great. And it looks like we are pretty much out of time here. I wanted to say thanks again for coming on such short notice. I mean, it was literally, I think, 16 hours notice. We really appreciate it. It's great to get caught up on everything going on at the Supreme Court. I'm sure it's going to be an exciting term, as you discussed. I would like to thank everybody for attending. Thank the Student Senate for funding. And hopefully everybody has a nice day. Thank you again.
Thank you so much, everyone. Take care.